Good afternoon. This is Baker Donaldson's webinar, Negligent Selection After Montgomery versus Caribe, what every logistics broker needs to know. Just before we get started, I wanted to do a few housekeeping issues. We will have a Q&A box, which you should be able to see. So if you would, go ahead and start loading up questions. Some of you have already done that at the pre-registration phase, and we appreciate that. So we will try to respond to those questions, and we are going to leave some time at the end of our presentation to answer your questions. So please use the Q&A box for that. Also, we want your feedback. We really want this to be as interactive as possible. We view this as an opportunity to start a conversation with you. Post-Montgomery, we've been having a lot of conversations with our clients, but we wanted to open this up to a broader audience and have the benefit of at least starting a dialogue with folks that are trying to think through some of these issues post-Montgomery. So there'll be an opportunity for you to leave some feedback when we have the complete survey at the end of the webinar. What we're trying to do today is use kind of our collective knowledge. We've got several folks within our firm that focus really almost exclusively on logistics and transportation. We have a national practice group that is dedicated to that. And so we put together a subset of that, and we have been working before the Montgomery case came out to try to track what we think could happen. And then since it's come out, have put together some practical things that I think the folks in the logistics business need to be thinking about. So with that, let me quickly introduce my colleagues. We've got, first of all, Rodney Dillard, who is a shareholder in both our Birmingham and Atlanta offices. He concentrates his practice in high exposure commercial and business litigation, complex transportation, construction, insurance defense, and complex tort litigation. And prior to joining Baker Donaldson, Rodney worked as in-house counsel for a large national insurance company. Next, we have Greg Jacobs, who is a shareholder in Baker Donaldson's Fort Lauderdale office. He assists clients across a variety of industries and complex tort matters, including transportation litigation, product liability, construction defects, and insurance coverage matters. And Greg represents clients in state and federal courts across Florida. We also have Ida Sassani, who is a shareholder in our Atlanta office, and she represents clients in high stakes, high exposure, bet the company litigation across the country with a focus on the southeastern United States. Her practice concentrates on defending motor carriers, logistics providers, and transportation companies in matters involving catastrophic injury, wrongful death, cargo loss, freight charge disputes, and also insurance coverage. And I am Scott Carey. I'm in the Nashville, Tennessee office. I was formerly the managing shareholder of the Nashville office and also chair of our national transportation practice. I focus much of my practice on representing and defending motor carriers and logistics brokers in a broad range of disputes, including breaches of transportation and logistics contracts, enforcement of non-compete agreements, and also cargo loss and damage claims under the Carmack Amendment. We all are members of the firm's 24-hour emergency response team, which means that 24/7, 365 days a year, if you or your company is involved in a accident, motor vehicle accident, you can call our website or call the number that is listed on our website. And we've got folks across our footprint from Texas, all across the Southeast and up the Carolinas that can assist you to investigate those accidents right when they happen. So with that, let's turn to the Montgomery case. I want to, I guess, first give a brief disclaimer. If you tuned in this afternoon hoping that we were going to give you the magic bullet about how not to get sued or how to completely and totally eliminate your liability, then you may be in for some disappointment. There is no such magic bullet. But what we do help to help you think through some of these issues. And basically, I hope that the takeaway from everybody at the end of our conversation today is to help you to put together and develop some defensible practices that will demonstrate that you have followed reasonable care in hiring motor carriers. So with that, let's turn directly to the Montgomery case. Rodney, why don't you kind of walk us through the factual backdrop of the Montgomery versus Caribe case?
Will do. Thanks, Scott. So first of all, happy to see everyone here. Thank you for joining us. So we are here to talk about the case that brought us here, the Montgomery versus Caribe Transport 2 LLC case. So I'll just dive straight into the facts. Plaintiff Montgomery sustained serious injuries that led to a leg amputation when his truck was struck by the defendant. C.H. Robinson was the broker that coordinated the shipment by selecting Caribe Transport as the carrier. Now, plaintiff claims that the broker negligently selected the carrier due to the carrier having a conditional safety rating with the FMCSA, which is the Federal Motor Carrier Safety Administration. So some of the issues that fall under the conditional safety rating, or what was found with the carrier, was that the carrier was found to have a history of being deficient in the following areas: driver qualifications, hours of service of the drivers, inspections, repairs, maintenance, and crash rate. So ultimately, how the Supreme Court received this case or got to this case is that the district court ruled in favor of the broker, holding that the F4A preempted plaintiff's negligent hiring claims against the broker, and that the claim did not fall within the safety exception. Scott, will you mute your microphone for a brief moment?
Sure thing.
The Seventh Circuit affirmed the trial court's ruling, relying upon established precedent in the Seventh Circuit. And the Supreme Court granted cert to resolve the circuit split. So the first thing here is important to note, there was a 2-2 circuit split on how preemption and the F4A worked. So the Ninth and Sixth Circuits held that negligent selection claims against brokers are not preempted. The reasoning behind that is that these claims fall within the safety exception because they concern the safe operation of motor vehicles. So that's the Ninth and Sixth Circuits. Now, the Seventh and 11th Circuits, on the other hand, held that such claims are preempted. And their reasoning was that the safety exception required a direct connection between the state law and the operation of motor vehicles themselves. So, for example, being regulations or claims against actual carriers or drivers instead of claims against brokers whose conduct the Seventh and 11th Circuit deemed to be too attenuated from direct vehicle operations. So ultimately, the Supreme Court held that the plaintiff's negligent hiring claims fall within the F4A's safety exceptions and therefore is saved from preemption. And so, interestingly enough, for a case that has kind of shaken up the industry, the reasoning was pretty straightforward. The court examined the plain language of the operative statute, which was 49 U.S.C. 14501 C1 and C2A. And those provisions, and I'm going to paraphrase, but the F4A prevents state laws related to price, route, or service of any motor carrier or broker with respect to the transportation of property. And then the other side of that is, however, the Act's safety exceptions provide that the preemption provision shall not restrict the safety regulatory authority of the state. And these are the 5 operative words that change the landscape with respect to motor vehicles. So in looking at the statute, well, first, before they got into the plain language and things of that nature of the statute, all parties agreed that the common law duties and standards of care form part of the state's authority to regulate safety. So that they weren't fighting over that. So the question was, with respect to motor vehicles, what does it mean? And so the court then determined that with respect to motor vehicles means concerns motor vehicles. That was kind of obvious, but I understand there was a split. Because the F4A supplies no definition of with respect to, the court applied its ordinary meaning, concerning or regarding. And that was consistent with Dan City Used Cars, Inc. versus Pelkey. That was a 2013 case where they actually went into what does with respect to means. And then they looked at the definition supplied within the F4A with regards to motor vehicles. And obviously, a motor vehicle is a vehicle, machine, tractor trailer, or semi-trailer propelled by or drawn by mechanical power. So ultimately, they looked at the plain language of the statute. They looked at the definitions of motor vehicle and with respect to, and then they came to the decision that any state laws that deal with motor vehicles falls within that safety exception. So interestingly enough, the facts of this case dealt with interstate shipping and not intrastate shipping. As such, the law is a bit unsettled regarding interstate loads. So Ida, if you would, just tell us, how do you feel the Montgomery decision impacted or impacts intrastate versus interstate shipping?
Yeah, thanks, Rodney. I think the answer to that question is we don't really know. As you just kind of covered, the Montgomery court answered a really specific question, and that's whether negligent selection claims against interstate freight brokers are going to be preempted by F4A or not. And the court said, no, they're not going to be preempted. But what the court didn't say is what that means for intrastate brokers. I'm not going to rehash the explanation you just gave, but I do want to clarify for our listeners that the safety exception that was sort of the linchpin and the basis of this decision only appears in section 14501C, and that section applies to interstate brokers and transporters, but there is a completely different subsection, and that's section 14501B that addresses intrastate transportation issues. And interestingly, for whatever reason, when Congress drafted and enacted F4A, they decided not to include a safety exception type language in the statute. So if it's related to price rates or price routes or services for interstate carriers, it's preemptive regardless of whether or not there is a safety implication. And the court in its decision talks about this distinction. It acknowledges it. I think they even refer to it as an anomaly and as a mystery, and even pointing that sort of different treatment out in the brief, they expressly declined not to go there because the only question in front of them was the safety exception as it relates to intrastate, I'm saying it backwards, interstate brokers. And I think by sort of raising this discrepancy and then doing nothing about it, it has shed light and drawn attention to this distinction that I think many folks, and here I'm in particularly referring to the plaintiff's bar, especially those folks who don't live transportation like those of us on this call, didn't realize that distinction existed. And now that the court has highlighted this distinction, I think we're going to start seeing litigants start to kind of wrestle with the question of why is there this distinction and should it exist? Should interstate brokerage activity be treated differently than intrastate activity? And given how aggressive the plaintiff's bar can be in their relentless pursuit of finding as many pockets as possible for each accident, I wouldn't be surprised if we start seeing some constitutionality arguments of how can F4A preempt purely intrastate transportation issues. Now, I don't want to wade into constitutionality here. That's kind of beyond the scope of today, and I don't want to predict where those challenges are going to end up, especially because I think Commerce Clause authority has been interpreted by our courts pretty broadly. But I do want to take this opportunity to sort of caution our intrastate brokers on the line who think that this is a victory. This is not the time to say, because I think what we are seeing, and we'll talk about this a little bit later, Montgomery's already, the reverberations are being felt in the courts. And I think we need to be worried about whether or not this preemption is here to stay for our intrastate brokers in the future. We may have won, we may not have gotten there today, but that doesn't mean a year from now, 2 years from now, that there might not be a challenge, or that there might be, this might be struck down as unconstitutional. So I really, from a practical standpoint, would caution brokers to really be thinking about, is this interstate or an intrastate load, and kind of using that to determine what they're going to do. I think, obviously, if you still got the preemption argument to make it while it lasts. But the better thing to do when you are designing your compliance and your carrier selection procedures is to really drill down, regardless of whether you got preemption in place, and have a actual defensible, documented carrier selection policy in place. And one other thing that's sort of semi-related, but the interest rate broker question is not the only thing, sort of what I'm going to call untouched by Montgomery. I think we've all gotten the email alerts and blasts that sort of kind of paint this doom and gloom picture of what Montgomery has changed, and not to minimize the change and the lack of the safety exception for interstate brokers moving forward. But I think I want to remind everyone that there is still preemption. If it's a law related to price, rate, routes, and services, it's still preempted. And even if we don't have a safety exception preemption for our interstate brokers, we're not creating new causes of action. We have just gotten rid of what I like to call a procedural off-ramp. So no need to panic. And we're going to give you some practical tips on sort of what to do now that we don't have this preemptive procedural hook for ourselves.
Yeah, and something else that kind of comes to mind in the interstate is, you would think that would be fairly easy to figure out whether it crosses state lines or not. But I think we're also going to see some litigation over what is really the meaning of those two terms, because it may not be all that simple when you're thinking about, last mile, for instance. So, for the brokers out there, you have brokered something that has come from outside the country, but the accident may have happened all within the carrier that's just making the move within a state. So I guess the bottom line is, even though clearly interstate preemption is no longer viable in a motor vehicle accident case, preemption hasn't gone away altogether, right?
Correct.
So let's, Greg, why don't you take us through effects that we're seeing impact on logistics brokers now that we've got this Montgomery decision out there?
Definitely. Thanks, Scott. So some practical impacts, right? So carrier selection is no longer just a commercial matching function. It is now a litigation file waiting to be reviewed if the carrier causes a serious crash. Now, as Scott alluded to in the beginning, there is no perfect checklist of what to do. Rather, the practical standard becomes, can you explain months or years later why this carrier was a reasonable safety choice for this load on that particular date? And to that end, as Ida mentioned, right, this Montgomery case doesn't create a new cause of action. Rather, brokers lost this procedural off-ramp that they so often enjoyed. Brokers can no longer rely on this preemption motion to dismiss and expect to be out of the case relatively quickly. Rather, the broker is now going to have to go through potentially extensive discovery, potentially a motion for summary judgment. And whether this is going to be business as usual or an opening of floodgates really depends on the jurisdiction you're in and if there's an existing claim or framework for a negligent selection claim.
So we've got basically, one of the issues now is brokers are going to be subject to all these different state laws, and there are differences, some of them subtle, but some of them pretty significant when you start looking at each state laws. And I think that was obviously the idea in the first place behind preemption, that you are in interstate commerce, and so you shouldn't be subject to all these different state laws. Now you are going to be subject to those state laws. So we wanted to just give you kind of a brief overview of what some of the differences are. So, for instance, let's start with Rodney in Alabama. We've got, in some cases, or in some jurisdictions, you do have a standalone negligent selection or hiring claim. In others, we don't. So, Rodney, why don't you tell us kind of what the landscape looks like in Alabama?
Will do. All right. So in Alabama, all of my Alabama brokers that coordinate shipments in Alabama, the sky's not falling, and there is no need to file for bankruptcy and close shop. All right. So as you can hear, our overall theme in this is stay calm. Stay calm. Okay. Currently, Alabama does not recognize negligent selection of an independent contractor unless the task is an inherently dangerous activity, which the Alabama Supreme Court has ruled in the past that transporting large loads does not constitute an inherently dangerous activity. However, the court will look to see if the broker has retained control over the carrier's manner and method of carrying out its functions. If the court finds a right to control has been reserved or exercised by the broker, then the broker could be held liable under the theory of vicarious liability. So ultimately, this has been the established law in Alabama for a very long time. So while Caribe does take away our early off-ramp, right? It's still not an automatic liability in Alabama. Greg, what is it in Florida?
So in Florida, Rodney, right, unlike Alabama, we do have a negligent selection of independent contractor claim. Florida does recognize that while a party generally is not liable for the acts of an independent contractor, that immunity evaporates when the selecting party was negligent in choosing an incompetent or unfit contractor for the work. So in Florida, the liability turns on three key elements. The first being that the contractor was incompetent or unfit for the job. The second being that you knew or should have known, so that's that constructive knowledge aspect of it, about the incompetence before hiring them. And then third and finally is this causation aspect, that the contractor's incompetence caused the plaintiff's injury. So that's what we have in Florida. And Ida, how do you all handle it in Georgia?
Georgia is a little bit more like Alabama. It is not like Florida. We've got some pretty good authority here. Granted, it's in dicta and in a franchise or franchisee case context, but we still do have a case that's not been disturbed yet by the plaintiff's bar. That negligent selection isn't really a recognized tort. And that kind of dovetails with a really strong statutory framework we have that, generally speaking, companies that hire independent contractors are not going to be held vicariously liable for their tortious conduct, coupled with some additional case law that says negligent hiring claims only apply in the true employer-employee context, not the independent contractor context. And Montgomery doesn't change that. It doesn't change the status of the law. So generally here in Georgia, if a broker's looking at liability, they can avoid it through a properly structured independent contractor relationship with whoever their carrier is. The only exception in where liabilities may lie is where the company doing the hiring of the independent contractor exercises such a degree of custody or control over the manner, means, and method of the contractor's work that it essentially converts it into an employment relationship. So what I've been telling folks, I've also been calming them down, but just be very, very careful in what your selection and your vetting process looks like, so that you are not creating an employment relationship by having too many controls in place. But a properly papered and properly conducted independent contractor relationship should be a shield from liability in Georgia. What about Tennessee, Scott?
Yeah. In Tennessee, we do have a standalone negligent hiring or selection claim. Under Tennessee case law, the relationship between freight brokers and motor carriers is typically treated as one of an employer and an independent contractor. And an employer is generally not held vicariously liable for the actions of an independent contractor. But a plaintiff can succeed in a negligent hiring case if they show that the employer either knew, i.e. actual knowledge, or by the exercise of reasonable care, might have ascertained that the independent contractor was not qualified to perform the work that he was contracted for. So in Tennessee, in order to recover for negligent hiring and supervision, a plaintiff must prove just the traditional elements of a negligence claim, that the employer had knowledge of the employee's unfitness for the job, but they also may be held liable if the employer knew or by the exercise of reasonable care might have ascertained that the independent contractor was not qualified to perform the work that he was contracted for. So you can see just by these 4 states that there are some fairly significant differences, and you're going to find that as you go throughout the country, and that's going to make a big difference when you get brought in on one of these suits on how that's going to go. I think that the next thing that we really need to look at then is, what does a defensible vetting process look like after Montgomery? Ida, you want to kick us off on that?
Yeah, I'm happy to discuss. Obviously, Montgomery is new. It's going to take a long time for, especially in our jurisdictions where there has been preemption historically, but for the body of law to catch up and really develop an idea of what is acceptable and what is not an acceptable carrier vetting process. But I think in the absence of that, right now, having at bare minimum a written carrier selection policy is going to be absolutely critical. I think, if you're brokering a load and there's been an accident, one of the first things a plaintiff's lawyer is going to ask is, well, what was your process for choosing this carrier? And if your answer, a couple years down the line is, I don't know, it depends on who booked the load that day, that's not going to be a very good answer. And so having a written policy in place, it's going to demonstrate that the carrier selection is systemic, that it's objective, and that it's consistently applied rather than some random ad hoc process that just depends from day to day. And it also helps ensure that everyone within the organization is also just generally operating from the playbook. So not only does it streamline it for litigation purposes, but it also kind of just helps people know what they're doing from an operational purpose as well. And now what that written carrier selection policy is going to look like is going to vary from broker to broker. We're going to give you the ultimate lawyer answer. It's going to depend. A small brokerage firm that's moving a handful of loads a day is going to have different resources, technology, manpower, and risk tolerance than some of our large national brokerage companies who are moving thousands, if not tens of thousands of loads per day. So I caution against anyone who's going to tell you that there is a one-size-fits-all carrier selection policy. At the end of the day, you need to be comfortable defending whatever your policy is and whatever your criteria is, whether that's sitting at a deposition and answering the tough questions about it or testifying in front of the judge and jury and explaining this is the policy you had in place. But I think at a bare minimum, all written policies should at minimum identify the information is going to be reviewed, the minimum standards that have to be met for approval, what issues, if anything, are going to require additional review or escalation. The policy needs to include how those decisions are going to be documented, and then how long information is going to be kept for. I think regardless of whether you guys as brokers are relying on internal reviews, third-party vetting platforms, some of these automated monitoring tools that are coming out, the FMCSA's databases, or some combination of all of those approaches, I think no matter what you do and how you do it, the process has got to be thoughtful, reasonable, and consistently followed, because those are the easiest ones to defend when Scott and Rodney and Greg and I get called to defend y'all in lawsuits. And I think a theme that you're going to hear from us is document it, document it, document it. Whatever standards you have, make sure you can prove that they are being followed, because a paper policy is not good if it's not being followed. And the plaintiff's bar isn't going to just take your word on, yeah, well, we said it was followed. They're going to want to see proof. And at the end of the day, you're going to have to just assess the business realities. And I don't know what's worse, not having a policy in place or having a policy in place that isn't absolutely followed. So don't chase perfection. Chase something that you guys can actually do, that you can actually justify, and that you can actually defend, rather than have some lofty million-point checklist that no one ever follows. You know, ultimately, I know we've said this a couple of times, but really sit there and think about it, because if something goes wrong, you're going to have to be able to defend it under oath. And that should be sort of your guiding principle as to, does this pass the red face test? Can I get up there and testify why we selected this process? Was this process followed? And, you know, and I'll pass the buck off to Greg. I don't think this should be a one-time thing that you just use one and done, Greg. What are your thoughts on that?
Exactly. So I think that's exactly it, right? Because we talk a lot about onboarding, and onboarding essentially answers the question of, is this carrier acceptable today, the day of onboarding? But what has to be equally as important is periodic rescreening, because that question answers, is this carrier still acceptable? And did anything change that I'm now going to be on the hook for knowing? And that last part's really important, because it's the legal risk in ignoring periodic rescreening, which creates the constructive knowledge, which is what you should have known, that aspect of the constructive knowledge that gets imputed upon for liability purposes. And so once a carrier is in your approved pool, right, your data continues updating every month. A carrier rescreen that shows a rising unsafe driving score, and if it gets filed away without any response, I mean, that's going to come back and bite you. It creates this evidence of constructive knowledge of, well, there was this accessible information that you should have known and did not do anything with it. You know, but the important catch of all of this is that the process, and as Ida had mentioned, has to be documented, right? Document your escalation path, whether that's the red flag being raised, the senior review, decision to suspend, restrict, or continue with, service. At the end of the day, whatever the policy that you're comfortable with has to be documented and consistently applied, even in the periodic rescreening process. So Rodney, go ahead, Rodney, if you could, I guess, fill us in on some carrier vetting best practices.
All right. Hey, Greg and Ida, did y'all say something about written policies? Yeah,
Maybe.
That's where I'm headed to.
Quite.
Written carrier selection policies. Write it down, y'all. Please write it down. All right. So some areas that best practices that I think that the brokers should really be focusing on is written carrier selection policies, as been discussed. Brokers should have clear, standardized policies that state the requirements for selecting a carrier. Also, there should be a clear policy on how to document the steps taken by the individual employee to follow the carrier selection guidelines. So yes, I know I said have a written policy about carrier selection and then have another policy about following those policies, because documentation is key. Like Ida said, having a written policy means absolutely nothing if your company is not following them, if your company is not following them consistently and uniformly, okay? So once again, there should also be a clear policy on how to document the steps taken by the employees regarding following the carrier selection guidelines. I would love for the brokers to also have documented trainings with its employees regarding the selection of a carrier. Think about it this way. Brokers, now you're in litigation. Plaintiff's counsel, show me your policies. Show me that you've followed those policies. Now, what if you all can go a step further and say, not only did we have a policy, not only did we have documentation showing we followed the policy, we also trained our employees on how to follow those policies. The name of the game now is insulation, making sure you're doing what is reasonable, okay? First thing the plaintiff's, as I stated, the first thing a plaintiff's attorney will ask for in discovery is the broker's written policy. If the broker does not have one, it's downhill from there, y'all. It's hard to defend something that's not there, okay? All right, the next thing is identity verification. At minimum, brokers should verify the carrier's U.S. dot number, motor carrier number, legal name, physical address, phone number, and email domain, and make sure that the information matches FMC SA records and other reliable sources like the Secretary of State's website, because there's a lot of good information about, companies registered within the state. If those basic identifiers do not line up, y'all, that's a red flag, okay? And if the carrier's email address, phone number, or physical address seems to consistently change every so often, every year, every 2 or 3 years, that's a red flag as well, and here's why. Accident occurs, what you will see from carriers is they will shut down shop in a heartbeat and just reopen under a different name. And so what does that mean for you as the brokers? That means your policy limits are the one in line. There are no other alternatives. Plaintiff's counsel is going to have a bullseye on the broker because the carrier will find a way to make themselves judgment proof. So protect yourself on the front end and pay attention to those type of red flags, okay? Verifying operating authority and registration. Brokers should confirm that the carrier's operating authority is active, that there are no out-of-service orders in place, and that the carrier is properly registered to perform the transportations being contemplated. Y'all do not have a carrier that is not rated or have the authority to handle chemicals, transporting your chemicals, okay? It's gonna be hard to escape liability on that. In practice, this means reviewing the FMCSA's Safer Company Snapshot and Licensing and Insurance database to confirm the carrier's authority status, operating status, and registration information before a freight is tendered. And insurance verification is the last thing I'll talk about. Review not only the declarations page, but also the policy itself to determine if the carrier's drivers are listed as additional insureds. And also look at the policy to determine whether or not the driver's names must be included within the policy and the amount of coverage provided under the policy. I practice in Alabama and Georgia. Georgia is one of those places where verdicts can be pretty large. And so having that minimum insurance may not be enough nowadays. You want to have more than enough coverage so that if you are directly in line to have to deal with a judgment, then it doesn't mean that your company is going to go under or something like that. Make sure you have the proper insurance coverage. Ida, do you mind talking a little bit about some of the red flags?
Yeah, there are definitely, I think, for our brokers here on the line, some red flags to be out on the lookout for. But I wouldn't say that there's any one particular thing, except maybe, just because the Montgomery decision spent so much time talking about it, it's this conditional safety rating, because that's the carrier at issue in that case had a conditional rating, and the decision does talk about it. So understandably so, a conditional rating, I think, should be an initial red flag. Does that necessarily mean absolutely do not use them? If I was defending it, I would say, please don't use them, but it's not ultimately the end all be all. I think at minimum, if you see something like a conditional rating, it's going to have to trigger additional review, additional documentation, and you're really going to have to justify why this carrier was approved. But again, I don't think there's any one particular red flag, except maybe, the carrier not having authority to actually haul the loads, that necessarily in and of itself is going to be a trigger. I think there is no such thing as a perfect carrier. Even our big sort of green flag, green standard sort of carriers. I had one for a client where we were in front of the Texas Supreme Court where the conversation was, if not Werner, then who else would be good enough for the plaintiff's bar? We're not limited to those. Carriers are not perfect. Even if you find those cream of the crop best carriers, they're going to have skeletons in their closet. They're going to have fatal crashes. They're going to have drivers who are out of service, vehicles who are out of service. And the plaintiff's bar is really good at finding that one thing you missed, or the one thing that you decided, oh, it's not a big deal. And then they make the mountain of the mole out of the molehill. That's what they do. That's what they've done. That's what they will continue to do. So at the end of the day, I want y'all to focus not on these isolated violations subject to those sort of big ticket items like not having authority, but look at trends and sort of what I like to call the objective indicators of safety. I think one of the easiest and most approachable metrics to understand are out of service rates. Vehicle out of service rates for carriers are about 22% across the country, and for driver out of service rates, and that goes to hours of service issues, med cards, all sorts of things like that, that's around 5 to 6%. To me, an immediate red flag is if the carrier I'm looking at is operating at worse than the national average on vehicle out of service and driver out of service. And I pay attention to that much more than maybe some of the crash data. And that's because vehicle out of service and driver out of services issues are something that are completely within the control of the motor carrier. A crash that's got to be reported to the DOT has got to be reported to the DOT regardless of who caused it. And so that crash is going to live there. It's going to be in the statistics, regardless of whether the carrier or the driver was at fault. So I don't think that is the best metric, but our vehicle maintenance, our driver supervision metrics, those are going to be the ones that really reflect a motor carrier's culture of safety, because that's what's in their control. The carrier can control their vehicle maintenance, their vehicle inspections. They can, if they're watching out on what their drivers are doing, they're making sure that they've got their medical clearance and that they're meeting their hours of service and taking their breaks and doing their inspections and all that jazz. So I really encourage brokers to pay attention to those things that are in the motor carrier's control, and also the trends. One out of service report might not be enough, but if you see a 6, 10, 18-month trend, especially if that trend is going down, that's a red flag and you need to look out. This isn't about just finding one or two issues. It's trends, averages, and I think that as brokers start looking at that, it'll become easier to sort of figure out who are the carriers who are doing what they're supposed to be doing and who is not.
Thanks, Ida. Yeah, we had a question. Where does one find a conditional rating? The Federal Motor Carrier Safety Administration has a SAFER, S-A-F-E-R website that you can go to. You can put in the carrier's name, their MC number, their DOT number, and it'll bring up that carrier, and you can find a lot of useful information about that carrier, their insurance coverage, whether they are actually authorized to do business in interstate commerce, and their safety rating is also on there. As this unfolds, you're going to see across the country different courts opining on some of these red flag issues and basically saying what's reasonable and what's not for a logistics broker. Ida mentioned from the Montgomery case that in that case, the carrier had a conditional safety rating. So I think that does explain that is probably a red flag that you want to consider when you're looking at carriers if they have a conditional rating. I thought it was also instructive just to look at some of the other actual facts in that case that were listed, at least by the plaintiff's counsel, as red flags. One was that driver that was involved in that accident had actually been in an accident just a few months before that one and had been cited for careless driving. And then going to Ida's point about looking at trends, when you looked at the Caribe accident history, they'd had 3 accidents in just a 6-month period, and they only had 9 trucks. And so that's another potential red flag. That doesn't necessarily mean that you can't use them, but that goes into the mix of should they be used or not. Going back to the FMCSA website, they had been deemed by the FMCSA on their CSA/SNS scores as a quote unquote high risk carrier. And the reason that they had been given a conditional safety rating was they had a number of deficiencies, including deficiencies related to driver qualifications, hours of service violations, inspection, repair, maintenance violations, and also a recordable crash rate. As we mentioned, that 3 accidents in a 6-month period. So, I think in the concurrence, the justice who wrote that indicated that you're going to have to ask some hard questions. For years, there has been kind of this debate. Do we have to, as brokers, really do anything other than just check the box of they are licensed by the FMCSA and they've got insurance, or do we have to do more? And I think clearly, based on the concurrence and the overall feeling in the industry is that there has to be more. We've already surveyed what the standard is in each state by state. And so you're going to have to do what's reasonable. And I don't know that you're going to feel comfortable just saying that we did absolutely the bare minimum. I think there's going to have to be more in terms of what your vetting process is going to be. Let's turn to the next topic that we wanted to talk about is contracting with your carriers. I'm curious to see what happens with load boards and kind of that whole segment of the population, because I think it's going to be really important for you, if you don't already, that you do a broker with each one of your carriers. One, just with this carrier, and it goes hand in hand with the fact that you've vetted them rather than just pick somebody off, I'm old enough to remember the phone book, out of the phone book or out of the computer that when you're going online and just finding somebody from a load board. So some of the provisions you need to think about, certainly indemnification. Not only should you have the carrier on the line to indemnify you for their negligence if you're involved in one of these third-party tort cases, but also it's important for them to defend you as well. And it's going to depend on, in some respects, the indemnification provision is going to be stronger in some states than others. Ida was talking about Georgia, where there's no standalone direct cause of action for negligent hiring or selection. I think the indemnification provision is probably going to be stronger in Georgia because most of that liability is going to be vicarious liability, or versus in Tennessee, you do have a standalone cause of action against the logistics broker for negligent hiring. And I can see, we've already seen this in the past, where the logistics broker has tendered their defense to the carrier, and the carrier's insurance company has said, well, the whole lawsuit is not focused on vicarious liability. There's direct liability against the broker, so we're not going to indemnify you. So you still need to have it in there, but you may end up fighting over that issue. We've already talked about insurance. I don't think that the minimum is going to cut it anymore. You probably really needed to look at making sure that your motor carriers can have more than just the minimum that's required. The other is the reps and warranties. I think this is a good place for you to tell the motor carrier what you expect them to do. One is pretty easy, that you expect them to follow the laws. The Trump FMCSA has been really active, though, recently in coming up with some new regulations, primarily centered around English proficiency and driver's licenses. And I think it's a good time to look at your contracts and make sure that they've been updated to have those types of provisions in it. Also, there's usually a general rep and warranty that says, carrier, you've told me the truth here. And that, again, goes back to when you're vetting, you're asking these questions, but now you've got another layer in the contract that said, you told me that you were telling me the truth when we were going through the vetting process. And if you find out that something that they told you was not true, then that can be helpful as well. Finally, I would say mandatory accident reporting. It's really important for you as a motor carrier to go out and investigate immediately any accident, particularly a catastrophic accident. But there are a lot of times where now the broker may not know about that accident for some time. So you need to have some mechanism in your contract that says that you've got to, as the motor carrier, report this accident in a timely fashion so that I can get my accident reconstructionists, my experts, my lawyers out there to help defend me as well. I would also say that I think a lot of these broker carrier contracts are on an evergreen basis. I talked to a lot of brokers who have these contracts, but they haven't renewed them in years. I would say that when we're talking about re-vetting your carriers, at least on a yearly basis, that's a good time to re-up your contracts as well. So I would put those two things together, re-upping your contract and re-vetting at least on a yearly basis, and so that you've got that kind of on a calendar basis. Quickly, I know that we've got mostly brokers on the line, but I did see that we may have some folks that are acting as shippers as well. And the brokers, you would want to have a client customer-facing agreement with your broker shipper provisions. This is the shipper's opportunity to make sure that the brokers are using appropriate carriers, because we've seen not only as a plaintiff bar started to file suits against brokers, but also the shippers, kind of under the same vicarious liability theory. And so shippers, you need to, for that reason, protect yourself with all these same provisions, indemnification, insurance, and whatnot. One note I will make for the brokers, though, I have seen some sometimes overly zealous shippers try to make your brokers act as carriers and take on carrier liability when it comes to accidents and also when it comes to cargo damage and loss. So make sure that as a broker, you're keeping that line as a bright line between what the carrier does and what the broker does. As we move on, we talked about conditional. We've also had some questions about unrated, and we all know that a lot of carriers, actually the majority of carriers, are unrated. So how do we help people navigate that kind of safety rating?
Yeah, and I think it's something like 90% of motor carriers are unrated. And I think as a practical matter, we've got to continue using them. There is just too much freight to ship and not enough rated carriers out there to have this chunk of the industry just not be available to move our loads. And I think really, and this kind of goes back to the theme we've been discussing all day, it's ultimately you've got to be able to defend hiring that carrier. Okay, so maybe they are unrated, but what did you look at to determine that you are comfortable and that they are safe with proceeding them? And this kind of goes back to make sure there's none of those red flags I was talking about. And whatever rating selection criteria you pick, you've got to be able to justify it. But I don't think that this, in our post-Montgomery world where there should be this panic, especially our unrated motor carriers, that they're never going to be hired again. I think really it's just being able to defend why you hired that unrated carrier. And there's a lot of other data out there that you can look at as a proxy beyond whether or not the FMCSA had the ability to audit and formally rate a motor carrier.
We've got about 7 minutes left. Rodney, why don't we quickly kind of cover some considerations from the plaintiff's perspective? What can we expect from the plaintiff's bar now post-Montgomery?
First things first, you can expect plaintiff's bar to sue brokers consistently now. Plaintiff's attorneys will go straight for the broker's policies regarding selection of a carrier. If the process, they're going to know, they will want to know if the process is documented and if there's proof that the process has been followed. Plaintiff's counsel will likely seek to determine if a broker has reviewed, asked for, or requires the carrier to have its own set of policies related to driver qualifications. And also, I think you'll see attorneys will be looking to see if the broker reserved or exercised control over the carrier, the driver selection process, or the carrier carrying out its work under any type of agreement that they may have with the broker. It is, and Ida has touched on this, and I will say it again, and this is extremely important for brokers. It is important not to cross over into the selection and managing of a particular driver, because as we've discussed, there are elements with, in Georgia and Alabama, even if it's an independent contractor, if it is determined that the broker has reserved or operated some level of control over the manner in which the independent contractor carrier carries out their duties, then they can be converted for legal purposes into an employee or agent where vicarious liability attaches to the broker. So it's very important that you don't cross over into that threshold of actually managing the driver. It's a fine line that you have to, it's a fine road to come walk through, but that's something to keep in mind. Regarding discovery, brokers can expect requests for written policies related to vetting carriers, drivers, and reviewing carrier safety ratings. This is a two-edged sword, because if you have policies but don't document them, document that you followed them, that can be evidence of negligence. But if you follow your policies and still select a horrible carrier, you can face possible liability as well. And so those are the things that you kind of can expect from the plaintiff's bar moving forward with regards to brokers.
Thanks, Rodney.
I am going to jump in if you don't mind. One thing, y'all, what I've been telling folks is keep your carrier selection file almost like a driver qualification file that our motor carriers take, because and this is what we mean by document. When you get that discovery request from plaintiff's counsel, you can go to your file and you don't have to go chase down emails, go into some, go on some wild goose chase trying to find documents. You've got your file with your written policy in it, and the documentation of who made the decision and what decisions were made. And that's going to make discovery a lot easier when the requests inevitably start coming in.
Already seen that, Ida. Some of the cases that had been kind of stayed in waiting for the Montgomery decision to come down. Now, all of a sudden, we're seeing plaintiffs' lawyers immediately submitting amended discovery requests, asking for that very thing, asking for your protocol, asking for those files that showed how you vet and how you vetted that particular carrier for this particular accident. So clearly, that's already happening. Let's do this. Greg, why don't you close us out with some thoughts on how the insurance market is going to respond here. I know that what we've been talking to our clients about is making sure that you've had conversations with your insurance company. And I think a lot of these insurance companies in their underwriting process are going to be almost helping you vet your carriers. I had one client that told me that it's likely that they'll lose up to 20% of the carriers that they can use because of their insurance company. So what are you thinking is going to happen in the insurance realm?
Definitely, Scott. And so you touched right on that. In the near term, I expect underwriters to scrutinize broker vetting programs as a condition of coverage, right? So carriers with documented system enforced vetting processes will be treated differently at the renewal than those running on informal habits. And higher insurance and documentation standards will likely become a baseline requirement to remain competitive and insurable. On that end, right, premium structures for contingent auto will rise broadly, I think, in the short term as the market reprices the now unshielded negligent selection exposure, with the spread widening between brokers who can demonstrate a defensible vetting process and those who cannot. Over the medium term, I think policy language will likely evolve to add explicit negligent selection exclusions, sublimits, or endorsements that tie coverage to document compliance with a defined vetting standard, meaning your internal processes will not just be your legal defense, but can also be a condition of your policy. And so that's where I see things going both in the short and medium term from an insurance perspective.
Great, thanks, Greg. Let's take a couple questions before we wrap up here. One question is, what is your exposure if double brokering? Are we more exposed or more protected from litigation if they hire a bad carrier? Throw that out to the panel.
I'll take a stab at this one. I'm going to give the most lawyerly answer of it depends on who the downstream, the sort of the second broker was. I think the problem with double brokering is that you lose control. You have no idea what the subsequent vetting process is and who they picked, how they picked them. You are just kind of putting your eggs in somebody else's basket and praying they don't drop and crack all your eggs, which from a defense perspective, that carries a lot of risk because you don't have the control. But, is it an additional layer of liability, an additional policy? Yeah, it's possible. But is losing that control and losing any semblance of ability to choose who the downstream carrier is worth that little bit of extra. Maybe I'm a little bit jaded. I would be uncomfortable with double brokering now that there is not clear preemption for our brokers anymore. There's a lot more risk, and that's why I think Scott touched on this a little bit. If you're going to have a contract, have a clear stance on whether or not double brokering is allowed, and if it's going to be prohibited, have it be written, because it's one thing to say, well, I told them, I was hoping they wouldn't double broker, versus having a contractual provision that prohibits it. And if you are going to allow double brokering, then you better have a whole section in your contract that's got all sorts of reps and warranties and procedural safeguards and indemnity obligations in place, sort of above and beyond what else is in the four corners of the contract. But I would really caution against double brokering these days.
Yeah, I would agree with you, Ida. I think that's a double-edged sword, and you'd be better off not doing it in the long run, I think. So one last question, and then we will wrap up. We are at our hour. Is there some sort of gold standard from an outside credentialing/certification agency for carriers, like the Joint Commission for Hospitals, that brokers could rely on as a partial defense? I think that the short answer is that there's no, if we're talking about the standard of care and what brokers need to do in order to vet, that's kind of the making all day, that there's not a formal list of things that you can check off that you can actually do to make sure that you don't have liability. That's something, looking down the road, the FMCSA might help us with. The transportation intermediaries might help us with that. Although my sense is that both of those entities would be somewhat circumspect in doing that and setting a hard and fast standard of care, because as we've said throughout this webinar, there's no one-size-fits-all for brokers. You're all in different situations, and it really comes down to what's reasonable. So I don't know. Right now, there is not a gold standard, and I don't know that we're going to see one coming forward. So with that, thank you guys for joining us. If you would, if you have any additional questions, please feel free to submit those, and we'll take a look at those and respond. You've got our email and our contact information if you'd like to have a conversation with any of us. I guess the bottom line, and what we hope you take away from today, is that brokers will see increased litigation as a result of this decision. You need to have a broker motor carrier vetting protocol. You need to follow that protocol. You need to document, and retain your records, do periodic reviews of your carriers, and then make sure that your contracts with your carriers are all up to date. And certainly Baker Donaldson, the lawyers on the screen that were part of the panel today, can help you with those protocols, with updating those contracts, and also just helping to talk through some of these issues, because it's going to be a continuing conversation. We're going to get more and more case law coming out, and as we do, we will try to keep you updated. I hope this has been helpful for you guys. Again, if you would, provide us your feedback so we can make sure that the next webinar is even better and addresses more directly any questions that you may have. So with that, we will be adjourned. Thank you all very much.
Have a good one now.
Bye, y'all. Thanks for watching.
Thanks, everyone.